This morning, the Supreme Court ruled on the question of whether the individual mandate in the healthcare reform law is constitutional. They deemed it to be constitutional, therefore upholding the entire content of the health reform law. The decision was that while it may not comply with the Constitution's Commerce Clause, it was allowable under our tax code.
You know, it was interesting how the court got to their decision, and it was very, very surprising that they used the ability for the federal government to levy a tax versus the Commerce Clause. And it was also interesting which justices decided for the majority opinion versus the minority opinion. The fact that the individual mandate and the entire healthcare reform bill is moving forward is not a surprise at all. In fact, it was one of the two scenarios we thought were most likely. For those employers who, based on their size, demographics, risk characteristics, and other business factors, have a commitment to aggressively managing their costs over the long term, nothing has changed. As a matter of fact, employers need to be more committed than ever to bending the cost curve based on the fact that healthcare reform is moving forward. The next big item on the agenda will be the election. As we all know, the Republican candidate Mitt Romney has vowed as one of his first acts to repeal the bill if elected. So attention now will shift from this Supreme Court decision to the election. But that doesn't mean that employers should suspend or should not continue to aggressively plan for the future.
Right. And in fact, I think we're anticipating that the supply side of health care will ramp up even more quickly to come into compliance with the requirements that are a part of the reform law. Things such as implementing accountable care organizations and being more mindful of quality requirements and things of that nature.
Diane, under the law, states are required to build healthcare exchanges so that individuals and businesses can purchase insurance. One of the interesting things is the different levels of preparedness and readiness that we observe when we look across the states. Some have enacted legislation, have already selected providers to begin to build the administrative platform behind those exchanges. Other states, Texas for example, have not even enacted the legislation required. With the 2014 deadline and the default going back to the federal government, it'll be interesting to see if the states who have not moved forward will actually put forth legislation to try to take control of these state exchanges, or they let the federal government come in and do it.
And as employers evaluate the options that become available to their workforce, it will be important to maintain an open mind and be creative in leveraging the benefit that these exchanges bring against the benefit that having an employer-sponsored health plan will bring. So there's lots of fast planning happening to get us to 2014. In
an environment where there is massive disruption, typically what we see is the amount of innovation surges. And we're observing that right now in the healthcare space. We are seeing new ideas every day, new vendors, new administrators popping up. So where are we? What's the bottom line now that healthcare reform bill has moved past the Supreme Court? What do employers need to do? They need to keep focusing on controlling costs in their health program. They need to look at taking advantage of the provisions in the healthcare reform bill that will help them control costs. For example, there may be situations where an employer will decide that not offering an employer-sponsored plan is a more economical decision than offering an employer-sponsored plan. There may be a situation where an employer will want to design a program so that a subset of their workforce will be able to participate in the state exchanges and receive subsidies, thus creating a win-win situation for the employees and the employer. Those things can only be determined, or those scenarios can only be validated through thorough analysis.
We understand that this is a time of a lot of change. There's a lot of turmoil in the system. Employers have been moving towards the expectation that this law would become effective. Now that it's confirmed, Lockton Dunning Benefits will continue to be here to help you navigate the system and navigate the options and be the jungle guide as we work our way through this very complex legislation.
At Lockton Dunning, we are committed to maintaining our leadership position with respect to healthcare reform. We formed our healthcare advisory practice 7 months prior to the passage of the original bill. Our practice now includes attorneys, actuaries, and other practitioners who not only are searching to understand the law, but also to develop creative and innovative solutions for employers. And we are absolutely committed to having a full understanding of the law and helping our customers leverage it to their and their employees' advantage.